This is Christopher Sanderson, and I am a realtor. This is a commercial contract for improved property. This is an offer that I received on one of my listings, and I just want to have an opportunity to go through it, talk about kind of a first glance reaction. So I did actually take a first glance and just run through and redact some of the identifying material in here. So anywhere where you see redacted information means that something was submitted, and I'll let you know what kind of information was there, but I'll refrain from sharing the specifics. But I'm a realtor. I provide both residential and commercial realty services in Florida, North Carolina, and Texas, all three states which I'm licensed in. And so I have experience with a few different states in terms of how transactions maybe differ a little bit from state to state, but right now I am here in San Antonio, and I'm taking a look over this contract on behalf of one of my clients, and I want to just talk a little bit about what kinds of things you'll see in an offer that you receive, and maybe it's going to be helpful for sellers, buyers, or realtors to just kind of see what that first take response is and get an idea of what information maybe could be added to an offer to make it stronger, or make it a little bit more correct if there's anything on the legality side or something like that that you want to make sure that you're really careful about. So let's dive in. Section 1 just defines the parties, and we're defining the seller and the buyer. So generally speaking, you can probably assume that since this is something I received from the buyer's agent, that you can assume this information here is going to be correct. But we have seen situations where that's not the case, so it's always worth double checking and just making sure that it's the actual full entity name of the entity purchasing the property. And I say entity because that could be an individual, that could be an LLC, that could be a corporation. There are different types of entities that could be listed as the corresponding parties. And then here you want to make sure to definitely double, triple, quadruple check that you have the seller information correct, because that's not necessarily something that the buyer's agent would know or would get correct. It's whatever they find online. Some of that might be something that you took time to make sure was correct everywhere that a property is listed. But with so many different types of commercial listing services, you might have listed it on CoStar or Crexi or even through your local MLS, and then somehow information gets pulled over to LoopNet with maybe an older seller name on there that's not accurate to the current name of the business, or whatever the case is. So just make sure that the information, especially for the party that you're representing, is up to date and fully correct. So then here we're going to see something in section 1 that's really important, and I'm going to highlight it here because this is something that we want to keep in mind as we read through the rest of the offer. It's going to shape the way that we evaluate whether this is an offer we want to consider going under contract with. And it says, or assignee. And what that means is that there's going to be a provision much later in the contract, and hopefully it should be checked off. My guess is that that's their intent, is to say that this contract, once executed, can be assigned to another party. And basically what that means is that if for whatever reason the buyer is not able to actually close on the property, or maybe doesn't want to close on the property at the agreed upon price, they could assign the existing contract to someone else rather than continuing to close or defaulting. So it gives the buyer a potential out. And for people who do this regularly, sometimes it's actually intended. I'll give an example right here. So let's maybe color code this a little bit. So this is not me marking up the contract, but we're going to just maybe over in this little area off to the right, we're going to give a little example. Let's look at your offer, and then the assignment of that offer, and then market value. So here's what sometimes people are intending to do when they leave open that option of assigning a contract. They're hoping, let's say property is gonna receive an offer of $200,000, $200,000. And let's say that they have calculated that the actual market value is $300,000. So they're hoping to submit an offer that's a little bit low. And it's likely going to be a cash offer when you see this. And then what they're hoping is that if they get the sellers to agree to that 200,000 price point as opposed to the market value of 300,000, then they can potentially assign that contract to someone else prior to close. Meaning, maybe they want to assign that contract to someone for 250, let's say. And that means that the buyers here, the buyers are making $50K just in that short period of time, in those couple months or whatever it is between the acceptance of the offer and then the actual projected closing. And then if you look for the person who that contract is assigned to, they're still getting a deal, because maybe they're getting a $300,000 property, but they're saving $50K. They're getting that $300,000 property still for cheap. So sometimes when you have an offer where they're allowing themselves that potential out of assigning it, that's how that assignment gets used. And a lot of people will try to enter into contract with the anticipation that they're going to be able to assign that by making an offer that is surprisingly low, for example, $200,000 on a property that they know is worth much more, like we see in this little example. So keep that in mind and see if you can spot where that comes into play a little bit later on here. Up next, a couple standard things. Again, you want to make sure that all the appropriate legal descriptions are correct. So here for the property, when they talk about what county it's in, the actual street address or its legal description, you want to make sure that you're just really careful. Attention to detail there, make sure we get everything right. Section B here, some people like to put NA in every line that doesn't have anything in it, just to make sure there are no changes added later on or updated without it being required to be signed by all parties. You can judge your own comfort level with that, but in full thoroughness, it's good to fill out every line that you can with relevant information. But that section's pretty standard, just says what's included here. So what conveys with the property. It's all buildings, improvements, fixtures, rights, privileges, interests and leases, licenses, third-party warranties, etc., etc., etc. All right, so for sales price here, so this is pretty much what we might expect on this. You have a sales price with a cash portion of $800,000, so the offer is $800,000 for the property. And then there's no financing portion. Their final sales price is $800,000. So offering $800,000 cash for a final sales price of $800,000. For the buyer's agent on this, you know, if you're the buyer's agent when you're submitting this, you probably should zero out this line just to make sure that it's clear that there's not going to be a dollar amount associated with the financing. Again, you don't want changes to be made, and I've seen lots of crazy things over the years, but it is possible that someone could just add in here, let's say $1 million. Then all of a sudden this offer of $800,000, well, is now $1.8 million. And it seems like such a clear thing that everybody would notice or, be on the same page with, but sometimes those types of changes can be placed in a contract, and when you're going back and forth through negotiations, a lot of times, especially in today's world of e-signatures, a lot of times a realtor's getting an offer or an update to a contract late at night. They're sending it over to their clients, requesting an e-signature. The client sees it in their email. Maybe they're even looking on their phone, not looking carefully. Click, 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 sign away. And then all of a sudden you have, a pretty significant change. So it's good to try to fill out everything that you can and make sure all the relevant information is in the appropriate place so that there aren't going to be changes added at a later point in time that you or your clients are unaware of. So here we get into financing, and so we already knew we weren't going to see any of these financing pieces checked off here because, as we saw prior to, they are doing a cash offer. So cash offer is going to really preclude this section on this one. All right, let's check out earnest money. So it says not later than 3 days after the effective date, buyer must deposit $5,000 as earnest money with the requested title company at, and again, you could probably fill in this info, but as a seller, you want to make sure that you have that info filled in. So for seller responsibility, that's something that's going to fall in your hands. If you do have a particular title agency you want to work with, a lot of title agencies have multiple offices, and they have, multiple individuals that, you might work with. So if you don't care who you use, you just like working with that company, you don't have to specify who's going to actually close it, but you probably have those relationships where you want to specify that it is going to be such and such title company located at this particular office, and it's going to be, Mrs. Smith or Mr. Jones who, we want to work with. You'd include obviously a first name as well with that. This is probably a little bit low, so we'll see if they want to offer a little bit more earnest money after a certain period of time. But yeah, usually you would say 1% is, kind of, the minimum for a really good offer. Sometimes there are extenuating circumstances, but, at least 1% is generally expected. So here, $5,000 on an $800,000 offer is a touch low. So I'll be keeping an eye out to see if they would deposit an additional amount. And if we take a look at this earnest money section, so they don't have anything filled in here. So I would maybe want to ask a question there and say, hey, could we maybe get a little bit more earnest money to make this offer a little bit more real? Seems like that's quite low risk for the buyers. But let's see what other specifications we find in the contract to determine whether or not that's something we would want to, make a big issue. All right, title policy survey and UCC search. So here, they just want to know if there's anything with the actual survey, if boundaries and encroachments and so forth are going to be amended, then how's that going to be amended and, at whose expense? So that's okay. That's not usually hugely consequential to whether or not a deal gets done. But it is helpful. I like to just keep a mental tally of what we're putting in the seller column and what we're putting in the buyer column, because that lets us assess the appropriate risk as to whether we go under contract. How risky is it? Is one party more or less likely to default? If they do, are the penalties more or less harsh to the other party, or to the defaulting party? So we want to just figure out, kind of who's got more skin in the game, as they say, as we read through. And here it says within 21 days after the effective date, the seller will furnish buyer a commitment for title insurance. And that's a reasonable amount of time. So nothing of huge, concern there. All right. So here they're talking about the survey, and they're not requesting any of these options here. So, again, usually I would, on the buyer's side, specify, what you're looking for in terms of, do you want a buyer to obtain a survey at the buyer's expense and give that, to the seller? Do we want the seller at the seller's expense to furnish the buyer with that survey? And again, these here, you're going to see this wording, but when you see that this is talking about dated after the effective date, this is talking about a new survey, or, and this is pretty common depending on how old the property is or how long the owners or tenants have been in place. For this third box, it says seller will deliver to buyer and title company a true and correct copy of the seller's most recent survey. So we're not talking about whose expense here, because we're not obtaining something new. We're saying, hey, do you have a survey on hand? But one of those should probably be checked. So usually for the number of days You can pick a pretty small number if you're just saying the seller has to submit what they already have, because that's likely something that they either have a hard copy of or something that they can find pretty easily. Sure, have it in their email somewhere. So if you're asking to obtain a new survey, you just want to make sure that you're giving time for that to take place and get done. So here, UCC is Uniform Commercial Code, and basically this is going to be for your particular jurisdiction, but this is going to talk about who and what has transpired transactionally on that property, and what items are there on that property, and it's going to be just basically a pretty in-depth analysis of exactly what you would find on property over the last 5-year period is what it is here in Texas. I know some states are different, so if your state is different, that's okay. But in that UCC search, basically, they want to see what kind of documents do you have on file that says, who bought what, who occupies what. It just offers a little bit of clarity. So that's something that I always recommend requesting. I think that that's, pretty fair, especially depending on the size and price point of a property, to make sure, this particular property that we're talking about is, roughly 10 acres of land. So it is really helpful to get an idea of what kind of documentation is on file relating to that particular parcel of land. Here, buyer's objections within 30 days. That's when the buyer has their window of opportunity to say, I don't like what I saw on this requested documentation. So if there is something that shows up on a survey or UCC, and they are going to use that as their reason to either renegotiate something or potentially step out of the contract, they have 30 days to do so. So again, that's a pretty fair period of time for a property of this size, and there's a few different kinds of businesses that have operated on the property. So there's a lot on this property that I think you'd want to give fair time for a buyer to evaluate the appropriate documentation for. In section 7 here for property condition, so they didn't request anything specific in this section. I think from something I saw when I was just redacting the info, I think they might have meant to put some things here as opposed to in a different section, but we'll talk about that when we get there. So this is what you want the seller to complete before closing, and for present condition, this means if you don't put anything, you're basically agreeing to the property as is, which I don't think they're really wanting this property as is based on what we'll see a little later on. So let's talk about that when we get there. For feasibility, so basically that gives the buyer a little bit of time. So in this case, 60 days, so a couple months, for the buyer to terminate the contract for any reason. And that's basically a chance for them to do their due diligence on the property and investigate a little further, review the appropriate documentation, and see if there is anything that's going to make them want to step away from this particular property. So again, that's your window for your buyer. And depending on the size and complexity of the property and what kind of factors are in play, you might see variations on that time. The greater that amount of time, the more favorable to the buyer. The smaller that window of time, the more favorable to the seller, typically speaking. So here we see 1A checked. If buyer terminates under this paragraph, the earnest money will be refunded to the buyer less. And usually you offer a certain amount to a seller because basically once you're under contract, right? So you're not actively marketing that property anymore or actively showing that property. Once you're under contract, you're expecting to move forward to close. So in this case, the $600 here, it's probably a little bit low for this $800,000 property to be taken off the market for, those 2 months, and to not actively be, trying to sell the property. So if the buyers did step away for any reason, as a seller, depending how confident you are that your property is, in good standing enough for that contract to close, you might request an adjustment in that amount, so that if a buyer did back out of the contract within reason, right, within that 60-day period of their feasibility, so they're not defaulting, they're electing not to move forward. And if they do, to walk away with $600 after taking your property off the market for that amount of time, I'd say that number should be higher for, again, a seller to more favorably look at the potential risk involved in going under contract with a certain type of offer. So higher feasibility, more favorable to when they put that that dollar amount. So the longer the feasibility period, the more favorable to the buyer, and the lower the dollar amount as concession, also more favorable to the buyer. And then here we also see an extension to this feasibility period, which basically means, hey, if we find along the way something that maybe we want to look into a little bit further or check out in a little bit more detail. So what if we want to extend that feasibility period? And here they have an extension, and they're asking to be able to extend by delivering $300 to the title company as additional earnest money. I'm guessing that's supposed to be $3,000. Would probably be my guess as to the intent with that number, because that wouldn't make sense here with 2A. But here, this is the amount of the additional earnest money that will be retained by the seller if the buyer decides to terminate. So I think that should be $3,000, and out of that $3,000, they're saying we'll give you $3,000 if we can extend another month. If there's anything that gives us hesitation in those first 60 days and we want to extend it so we can investigate a little further, we'll give you $3,000 to do so. And then if we decide to terminate, you'll keep $500 of that. So in total, the sellers here, if they went under contract and this 30 days on top of, because remember, this is an extension, so the 30 days on top of the original 60 would be 90 days off market, and the seller would walk away with $1,100 as consideration for that time. Still very low, but just keep an eye on the feasibility period extensions, because it can add up to a pretty long period of time, because we're still not yet at closing, right? So you might get to the end of feasibility and then have another delay in time before we hit the closing table. So just careful with what those delays look like. You don't want a seller to have to take that risk of losing out on 6 months of possible offers and potentially better contracts because maybe a buyer has made an offer that is asking for a little too much. So you want to be careful with those timetables there. Most of this is going to be standard contract language. Again, you should read through all of it, but there's nothing here really to point out specifically about what we're considering about a particular offer. So now we get into paragraph 7D. So here, this we do want to look at. So delivery of property information, so within 30 days. Again, that's a pretty fair time period to get all the appropriate documentation together, but let's see what they want. Copies of all current leases, mineral leases pertaining to the property, including modification supplements or amendments to those leases. So that's pretty fair. We see that commonly. That's usually, something that, again, people should have that documentation on hand. If you're worried about a particular business that maybe isn't great with paperwork, then when you are originally meeting with your sellers, these are great things to start requesting them to find access to. So, hey, it's time to do our homework. Let's kind of dig through those, wherever they keep it, and drawer in an old filing cabinet, or, an old email that you haven't checked in a while, whatever it is. But let's start digging through and making sure we have access to that. Current inventory of all personal property to be conveyed. under this contract and copies of any leases. So this one, we want to make sure that we are in good communication with a tenant, because that needs to be very clear, especially if you have a tenant who's going to move out. You want to make sure that a tenant is not leaving an expensive item that they were planning on coming back and getting, but they were confused about a closing date, and technically that's personal property that would convey with the property because it was on property by closing. And at the same time, you don't want a tenant to vacate and say, hey, I don't feel like throwing all this stuff away, so I'm just going to leave some junk here, and have that convey. So you want to be clear about what is or is not going to convey with the property, and that's what this is asking for, a clear inventory of. Copies of all current service, utility, maintenance, and management agreements relating to the ownership and operation. So that's basically, the way that you operate that property and keep it in good standing. Do you have an annual HVAC maintenance plan and things like that? You want to see what agreements are in place. Do you have a termite prevention plan in place? And if you do have those agreements, sometimes those agreements will carry with the property for X number of years. So there can be value to those. You want to make sure that you're clear about what is going to convey with that property at the sale. Copies of all current warranties and guarantees relating to all or part of the property. So this is more like warranty on, let's say, an AC unit that's staying with the property. It's not about your actual maintenance, but similar idea as to keeping that property, operational costs for keeping it in good standing. You've got an AC unit, and you replaced your 2 outdoor HVAC units last year. They came with a 5-year warranty. You want to make sure you've got a copy of that warranty, because if it's got 5 years on it and you're selling the property a year later, well, then you've got 4 years of warranty that you want to make sure the new owners will be able to benefit from. And again, that can add value to the property for a seller. And then here, insurance policies, pretty straightforward. What you carry insurance on, you want to make sure you have copies of, or at least access to, it can be electronic versions of those copies of all that information. A copy of the as-built plans and specifications and plat of the property. So there are certain things that you can't always tell, even with a pretty thorough inspection. And if you have full plans and specs, that's great. Not every property does. This one, I think, is a little bit more hit or miss, but this is something they're requesting. So I would advise my sellers that if you do decide to accept this offer, then you're going to have a month to find that documentation. So again, let's get going now. Try to be ahead of it and make sure that you start finding the appropriate docs that are being requested. Or if it's something that you absolutely can't find, it's not something accessible through public record, it's not something you can find anywhere, not through an old email, not a physical copy of, then you might have to counter with an amendment to the information that you're able to provide and see if that's something that's a deal breaker on the buyer side. Copies of all invoices for utilities and repairs incurred by seller for the property in the 24 months immediately preceding the effective date. So that's good to hang on to. Again, I like just having a drawer where anytime I have a vendor do anything for a property that I own, I'm just tossing it in a drawer in a file for that property. So if you live at 123 Main Street, if you have someone come fix a leaky sink and they charge you $100 for that plumbing service, great, throw that invoice in a drawer. If you have somebody, come and repaint the exterior of the property, throw that invoice in a drawer. And it's really helpful to keep those on hand. So this is a really helpful tip for sellers. A lot of people, I think, undervalue their properties when they've maintained it really well, because they undervalue the amount that they've spent on that maintenance. Because especially for smaller expenses, they don't always recall, some of the things that they've had done on a property. So if you do a $50,000 roof repair, well, you're probably going to remember that. But if you spend $200 here, $300 there, $500 there maintaining a property, and some of those different kinds of, repairs that you do, again, might come with certain warranties on that repair, please keep those invoices and, keep the reports of the work done in an accessible place so that when you get ready to sell, you can really understand the value of the maintenance that you've had done to the property. And then copies of all previous environmental assessments, geotechnical reports, studies, analyses relating to the property. That's fair on this one. So this is a property, and we're in Texas, so we're talking oil and gas for this particular property. So you're definitely going to have, environmental concerns being something that, are included in a contract. Real and personal property tax statements. So you want to get that real tax information. Occasionally, some of our listing services don't always provide that accurately when you're looking at, the information provided on something like, CoStar, Crexi, LoopNet, your MLS, whatever it is. And then tenant reconciliation statements. There is an existing tenant on this property. So basically, they're asking to see, hey, what kind of tenant do we have in place? How much are they, paying for, like, the occupancy of that space and what's required out of that tenant. Are you charging them a triple net lease? Like what's going on, with the tenant financials. So they basically want to see as much of the tenant financials as possible. And again, you should not necessarily be able to share the direct financials of that business operating out of the space, but your own financials of your relationship with that tenant should certainly be something that you already have, on file and easy to access. All right, return of info. So this basically says that if the contract terminates, who's going to keep what? And it should say that you're either going to return to seller or delete or destroy. And it should be, typically speaking, it's anything other than an electronic format. So here, actually, let me highlight that instead. But if it's other than electronic, that means you return it. If it's electronic, you delete or destroy it appropriately. So that's just to provide the seller with a little bit of security that when they present you with some of these things like surveys and, some of the financials related to the property, what you've had done maintenance wise, what you're spending on, your HVAC system that, you had repaired, 6 months ago. Some of that is, personal financial information, to those owners that should not be shared. Here, leases. So this is just going to be any leases assigned. So that's if you're taking an existing lease and assigning it to a buyer and they're going to continue with the existing terms. So if you have a tenant in place for 2 months and then you sell a property and that tenant has signed a 3-year lease, then you might be assigning an existing lease. Or there might be language in the actual lease terms that says it can be renegotiated upon sale of the property. You might not have a tenant in place. You might have a tenant that is in place on a month-to-month lease. So that's something that if something is going to be assigned and at closing there's going to be a transfer of lease to that buyer, then you want to make sure that you have copies of all that information so that the buyer can see what the terms are of that lease and decide how to proceed or factor that into their own financials, etc. Here we're looking at estoppel certificates. So they put an NA here, which means basically that there's no need to worry about the estoppel certificates. So that's something that we can not take too much of a deep dive on this one. And here are the brokers to this sale. So it's my name. They have me listed there. Seller's going to pay principal broker the fee, schedule, and separate written commission agreement. So that would be your listing agreement that you have with the seller. Closing 30 days after the expiration of the feasibility period. So just remember here, feasibility period is the 60 plus 30. So we have 90 days total if they extend the feasibility period, and then another 30 to close. So that's 120 days. So if they do accept this offer, that means you're looking at about a potential 3 or 4 month period prior to closing. And then here in Part C, so this is just the type of warranty that you're going to have. And part of the standard language there is that you're conveying the property without lien. So all of that would get, cleared up at closing. If there was anything, obviously title would be on top of that throughout the transaction. But they're saying that we're assuming that by the time the property closes, we've got no liens, like defaulted loans, any, when they say trespassers, so again, depends on where the property is located. If it's a vacant property, that is something that you want to make sure that, there are no persons who have, set up camp, started squatting on the property, started living on the property. So some of this, language is really just to avoid worst case scenarios, and it's good that it's in there. But this is something you can read through once and understand thoroughly, but you don't have to read through it on every contract or every offer, because there's not necessarily going to be places to amend, some of this information. So here's an interesting one, and I know I alluded to it earlier, but under special provisions, so it says the following special provisions apply and will control in the event of a conflict with other provisions of this contract. If special provisions are contained in an addendum, identify the addendum here and reference the addendum in paragraph 22D. And we can take a quick peek ahead, but I don't think that addendum is going to be referenced. Let's check. I don't think I saw it. So here, no. Okay. So yeah, the special provisions addendum is not highlighted there. Okay. That's fine. So they're including some special provisions here. And this, if this is to control in the event of a conflict, well, then that means that this is definitely something that should be worded very specifically. And I recommend reaching out to counsel. If you work at a larger brokerage that has in-house counsel available, that's great. If not, it's always good to have a real estate attorney if you are going to ask for special provisions, just to check the language on that. Because this part, probably more so than any part of the contract, should be abundantly clear. And let's read through this. It says, tenant should be completely moved out before closing. Seller to remove everything from building and clean up building. Clean up oil and chemicals on ground. Remove battery tanks. Remove all junk. Tires, chemical barrels, all pipes, everything that is not attached to building. Remove pile of brush, clean up pits where stuff was buried. Okay, so I would say that this section, if you're submitting an offer on behalf of a potential buyer, this section should be more specific and worded a lot more carefully. So this one is definitely maybe an example of something that my guess would be that this was realtor added. I mean, some of the writing, typically if it's done by an attorney, it'll usually be very clear and direct, really specific language, and very grammatically correct. And here we definitely have maybe a couple of no's in a few of those spots. So here, for example, ambiguous language, I'll point out what I see. And again, I am not an attorney, so this is not an attempt to offer any type of legal advice, but I just want to point out what you might see that would be worth clarifying. So, tenant should be completely moved out. Okay. Well, what does that mean? Does that mean that people are not physically there? Does that mean that they haven't left behind a piece of paper on a desk? Does that put you in default? So what does completely moved out mean before closing? Seller to remove everything from building. Again, everything's a little ambiguous. They try to clear it up later by talking about what's not attached, but that's still a little open-ended. Here, building, and that should just be 2 words. So again, little mistakes like that, I'm a little bit picky about those, but to me that says what's the level of detail and attention to detail and really careful consideration that the other party is going to keep an eye on. And any of those little things are sometimes an indication that you might have to pay a little more attention to detail because the other party's not paying as much attention to detail. So everybody responds to that differently, but I'm I'm a little bit of a grammar nut, so I don't love it when I see things that are kind of riddled with those types of even tiny little typo types of mistakes there. Let's see. Clean up oil and chemicals on ground. So not sure if there's a specific place. Again, we're talking about a 10-acre property. I don't know if they're talking about on the ground in the building. Is there a place where maybe someone with some dirty boots, got some oil or chemicals on the ground, like in the warehouse? Are we talking about, a particular concentrated point on the property? That's a little bit unclear there. Remove all junk. So junk, a little bit of an ambiguous term. Tires, I think they probably mean to have a comma there. Tires, comma, chemicals barrels. I think it would just be chemical barrels. All pipes. So I don't know if they want us to remove all pipes. Like, what about pipes that are necessary parts of the property? I mean, we have a gutter system on the property. We have plumbing inside of it. So there are some pipes we probably want to leave there. So I don't know if they're referring to particular loose pipes or what. So everything that is not attached to building, believe it or not, even though that this sounds open-ended, by saying not attached to building, that actually provides more clarity than a lot of the descriptions elsewhere in this paragraph. Remove pile of brush. Clean up pits where stuff was buried. Oh, stuff is definitely. So yeah, a lot of language here that, again, I think this is probably something that on the realtor side, if you are going to have some of these requests, you can add them in a different place. And I think I mentioned it briefly because they did not check it off here, and I was surprised that they didn't request anything because of those special provisions. And that was up here where we were talking about the beginning parts of this contract. And so let's see, so those were my big asterisks. They didn't say additional earnest money here, but they did fill that in later with the feasibility. And then, so they didn't check off anything here for the survey. And then I don't think they did for property condition as well. They didn't check off anything for seller's expense here. Yeah. Interesting. Okay. So yeah, it looks like some of the things that would oftentimes be included in other areas of the contract that they are trying to tie in down here under special provisions, and it's a big no-no. So definitely I think some work to be done, on this offer before, knowing my sellers who like to be very careful and thorough, would be interested in evaluating. And here they talk about what's typically going to fall under seller and buyer expenses. So that you want to just make sure is going to match up to anything requested in other parts of the contract, but there's no specific language there that you need to worry about on an offer. Same thing here for the prorations and rollback taxes. So again, that basically just says time of year when you close. You take that date and you prorate who's responsible for what. So if people have prepaid taxes for the year, then there's going to be some prorated money going back. For what it means to default, so it says seller may pursue or enforce specific performance or seek such other relief as may be provided by law. So this is typically going to be anything that if the buyer does default, that the seller can, whatever is provided by the law. That sometimes can differ state to state, but basically it says that if the buyer defaults, the seller can take some type of recourse in order to recoup some of those losses. Loss and condemnation. So basically, this is, hey, what if something happens? So if there's some version of natural disaster, so, by fire or other casualty after the effective date, the seller must restore to its previous condition as soon as reasonably possible. And again, that would depend on the event described. So if you have a flood that does no building damage, but maybe, parking lot floods for a day and you need to sweep some water out and let it dry, then that's reasonable to expect, and there would be an appropriate time period that you would discuss, for what that might take, and sometimes that can be more back and forth conversation, because that oftentimes works in both directions. If there is something that happens, let's say citywide or statewide or regionally, like a larger natural disaster type of event, then oftentimes that affects both the seller's ability to have the property prepared in such a way so that it's ready to close according to the provisions of the contract, but sometimes it also is going to delay the buyer's ability to be ready to close as well. And that's, I've run into that twice, and in situations where both parties were affected quite similarly, and so it usually makes for a pretty easy discussion because both people are scrambling on their end to try to get things restored before they're able to then make the appropriate sale and then move and then close. Attorney's fees. Well, let's check here to see if this even matters, because this basically, and you'll see this language, but you'll see reasonable attorney's fees, and this is awarded to prevailing party. So basically, if a lawsuit arises as a result of this contract, whoever wins is entitled to not only what they sued for, but reasonable attorney's fees, which can be really significant. So keep in mind, if an attorney charges, if in your area $500 an hour is a reasonable fee, which it probably is in a lot of cases, so that means whatever the issue is that you're taken to court because of some sort of breach in a contract or whatever it may be, it means whoever wins is entitled to, let's say they're suing you for $10,000. Well, if it took that attorney 20 hours at $500 an hour, well, that's going to be another $10,000 that you'd have to pay on top of that if the other party is the prevailing party. So just keep that in mind for attorney's fees. Let's see if we have attorneys involved, and they could always retain counsel at a later time. That doesn't apply to people who have attorneys already, but I think they did, right? Yes. So here, they already have attorneys in mind. So that means that is something that you want to keep in mind, that the attorney's fees provision in there would be something that, if, again, sometimes everything runs perfectly smoothly, but if something did arise, they do have attorneys in place, and they're kind of ready to go for that. Here for escrow, it basically just says, hey, the owner's money is going to be held in escrow, and it's going to be distributed to the appropriate parties, like at closing, or credited towards the purchase of the property appropriately at closing, returned to the appropriate party if someone defaults, etc., etc. So this just outlines the way that escrow works. Escrow is just a really fancy way of saying somebody hanging on to your cash for you. So you say, I want to buy this property for $1,000. Here's $1,000. And then someone trustworthy, so the escrow agent, hangs on to that $1,000 and says, okay, it's like one of those exchanges you see in the movies. All right, instead of you hand the guy the suitcase and the guy hands you the money, you both hand it to a third party, and then there's an exchange. And that's really what your title company is doing for you in the sale. Material facts to the best of the seller's knowledge and belief. So this, sellers do have to disclose. So this, we advise disclose everything. And this, you want to have a pretty detailed property condition statement so that you can make sure that, your seller is alerting a potential buyer to any potential issues with the property. You always want to be as transparent as possible. It's going to come up at some point, and it's only a really big issue when it comes up really late in the game. So you don't want it to disrupt a potential closing, and you don't want it to come up 2 years down the road or whatever the statute of limitations might be in your state. But you don't want to, have an owner of a property run into an issue and find out that, there was something really wrong that sellers potentially knew about and should have disclosed a few years before. And, now they're going to have to go and, revisit the last few years of, their use of that property, what the seller actually disclosed. It can be a much bigger deal when it shows up later. So just be transparent with that and encourage your sellers to be as transparent as possible there. Notices must be in writing. I mean, that I think in today's world is pretty easy to do. And you can consent to email as version of notice in writing, depending on the comfort level. Usually that's going to be what your seller or buyer agrees to. So sometimes someone who's a little bit younger and more tech savvy, for example, might say, "Oh, I love email. I only work off of email. Like, don't ever mail me a letter. I don't even check my mailbox." And somebody who, enjoys getting that physical copy might request that. So fair either way. Agreement of the parties. So again here, contract binding, and to include the following addenda. And here we see that they've only checked these couple, which are the property condition statement and the IABS. Property condition statement, like I said, that's something you want to make sure your sellers have filled out thoroughly. So that should be something you already have on hand and can share ready to go when discussing an offer. And then, so this is exactly what we expect to see here in 22E. Buyer may assign this contract. So that's what we're expecting. And likely, based on this particular offer and the contract as a whole, that's likely the intent here. It's someone hoping to get an offer approved. So my guess would be that I don't know that my clients would say yes, but hey, guess what? We're going to submit it anyways because that's what we're required to do. So we're going to send this offer over. And those are just my initial thoughts in reading through this. I'm going to send the offer and make myself available for questions, but my clients are pretty savvy sellers and have dealt with quite a bit of commercial property in the past. So my guess would be that this is something that they'll be able to look at in pretty significant detail here and understand these different contractual provisions and make the decision that's best for them. And, I trust them to do a great job with that. And then down here, agreement between the brokers. So this is just them requesting that 3% of the sales price is what would go to the cooperating broker on this. Like I said, it shows that they have an attorney in place, and that's it. So that's a commercial contract for commercial improved property here in Texas. This is what an offer looks like. There's some things in there we would definitely want to take the time to clean up, but overall, we can at least pass this initial thing on to our sellers, make ourselves available to answer any questions that they have. If they do want to counter with anything, specific or change anything specific, we'll communicate that back to the buyer's agent. And typically when you do receive something, you want to, at the very least, just let the buyer's agent know that you've received it. So on this one, as soon as the email came in, prior even to forwarding it to my clients, I just sent an email response really quickly to say, hey, we've received your offer. We'll take a look and evaluate it and get back to you as soon as possible. And, then at least they know that everything went through as expected, and they won't hound you, the next day or next minute with a million phone calls. So definitely really helpful to do that. But hopefully that was a good sample of what you might see. I know that's a lot of detail, and some areas of a contract might be a little more interesting to some of you than other areas, but this one, does at least check a lot of the boxes of things that you'll see in any type of contract that you evaluate, and, things to, both not worry about too much because it's common, or things to keep an eye on because you want to make sure that all of the language is as complete and thorough and correct as possible so that you can take care of your client's needs as best you can.